The right to be forgotten emerged prominently from the Costeja Judgment by the Court of Justice of the European Union, CJEU, in May 2014. It allows individuals to request the removal of links to web pages containing their personal data from search engine results, based on specific grounds under GDPR. Since the judgment, there has been a significant awareness and uptick in complaints against search engines like Google for not delisting URLs as requested by individuals. The guidelines underscore that while Article 17 of the GDPR is applicable to all data controllers, this document specifically focuses on search engine providers. It differentiates between the processing of personal data by search engines and that by publishers of third-party websites, emphasizing that delisting does not equate to erasure of the personal data from the web. Grounds for delisting requests. The guidelines outline 6 grounds under Article 17.1 GDPR for a delisting request. 1. Personal data no longer necessary. Data that is outdated or no longer relevant for the purposes for which it was collected. 2. Withdrawal of consent. When the individual withdraws consent, which was the basis of the processing. 3. Right to object. If the individual objects to the processing of their personal data. 4. Unlawful processing, if the data was processed unlawfully. 5. Compliance with a legal obligation. Data that must be erased to comply with a legal obligation. 6. Information society services to a child. When data was collected in relation to the offer of information society services to a child. Exceptions to the right to delisting. The GDPR also enumerates exceptions to the right to delisting, including when processing is necessary for exercising the right of freedom of expression and information, compliance with a legal obligation, or for performing a task in the public interest. Reasons of public interest in the area of public health. Archiving purposes in the public interest, scientific, historical research, or statistical purposes. The establishment, exercise, or defense of legal claims. Implications and balancing test. A critical aspect of these guidelines is the emphasis on the balancing test between the individual's right to privacy and the public's right to access information. The EDPB recognizes the complex interplay between different rights and interests, including the pivotal role of search engines in facilitating access to information. The guidelines also highlight the distinction between the erasure of data from the web and delisting from search engine results, pointing out that delisting does not remove the data from the internet but rather makes it less accessible via search queries based on the individual's name. Conclusion. The EDPB's guidelines provide a structured approach to assessing and handling requests for delisting under the GDPR, emphasizing the need for a careful balance between personal privacy rights and the public interest in information access. As the digital landscape continues to evolve, these guidelines serve as a critical reference point for search engines, data subjects, and regulatory authorities navigating the complexities of the right to be forgotten.